I think let's start in time and stop in time.
Yeah, yeah, yeah. Yes, yes.
ભાઈ કાકીના
Jatinji, can you
ખબર ને
start?
બધાના માઇક્રોફોન ઓફ કરાવડાવે જેથી કરીને સ્પષ્ટ સંભળાય.
Yes, yes. We can start now.
All right, friends, good morning, and my wishes to all of you on this unfortunate situations what we are facing since almost 3 weeks. Thanks to the GIS for creating this wonderful platform, though it is very small and cozy, but I'm sure that the topics which we all of the core members to bring on the table, that will be beneficiary to the each of us, and these are gonna be, I've seen the couple of other speakers who are speaking in line. They all are speaking on a very diverse topic which probably we have never discussed in our meetings, or whether we have never discussed with anybody else. So when the approach, the GIS offered me this opportunity, I thought that though being from the intellectual property field, let me not talk about the intellectual property, but we should talk something which is real-time concern, and we should also know something which is really affecting to us. And I've seen that, you know, when matter comes of learning the law, most of the just pardon me, my all industry friends, but most of the industries run away, and or they go to their consultants or the legal consultant or the legal representative and come to us, a person like us, and say, yes, Mr. Trivedi, guide us what is to be done. When I was studying law, I completed in 98. When I was studying law, one of our constitution professor has said some time back that while drafting the Constitution of India, the Baba Sahib Ambedkar and the Sardar Vallabhbhai Patel have insisted that you should have a clause or article into the Constitution that law is something which every citizen should learn, rather every citizen should know at least about their rights, right? So whether you're right or wrong, when you are stuck up at some place or doing something, when I say something, it's obviously a business herein. So I thought that let me just address all of you, being having a law background. Let me interpret what is Section 144, right? I'm sure many of you must be aware, or rather all of you must be aware, that Section 144 is quite in a talk, and we have been reading in the newspaper that Section 144 આપણા દેશમાં કે આપણા સ્ટેટમાં કે આપણી સિટીમાં Section 144 લાગુ કરવામાં આવી છે, એટલે આ કરવાનું, એટલે આ કરવાનું, એટલે આ કરવાનું. So we follow that rules and regulations which is guided by the government. Precisely, I have 15 minutes to talk, right? Sunil Bhai, Tapan Bhai has lost, I believe that. Sunil Bhai, right? I have 15 minutes to talk. I will just crisply go to the section. A bit of portion of my talk will be little dry because it will start with the law reading, which probably none of you might have ever done, and I wish that you never do it in a life as well, because law is something troubling to the industry when it comes to their own desk. So Section 144 is of the CRPC. It's a Code of Criminal Procedure. It defines the procedure of how the magistrate shall pass an order directing the public to abstain from doing certain things which will be considered as an act of criminal nature. Here, when we are talking about the lockdown period, or we are talking about the situation what we are facing in the COVID-19, here the criminal nature is unlawful assembly. So friend, I will just refer the situation as the COVID-19. However, the definition of the unlawful assembly has been defined under Section 144 of the Indian Penal Code, right? And the punishment thereof is defined under Section 143 of the Indian Penal Code. unlawful assembly is that you more than 5 people gather at a one place and having some motto of doing some crime, right? So there is a bit technical part of it, so I will not go into it, but that is section 141 and 143 of the Indian Penal Code defines that what are the penalties and what is mandate. Before we go further, I think we should know that how the criminal law works, right? We often know that there is a CRPC exists, there is an Indian Penal Code exists, there is an Evidence Act, but friends, let us understand that how the criminal law functions. So Indian Penal Code, it defines the crime and the punishment. So what is a crime is unlawful assembly, and what is a punishment is a 143, as I said, right? So that's Indian Penal Code, and a Code of Civil Procedure, that is CRPC, as we normally familiar with, it lay down the procedure of conducting or lay down the procedure, right? That what is to be done, how it is to be executed, and the Evidence Act is obviously how the trial can take place and how you can prove your cases. So here the concern is not the Evidence Act, but at least we should have the sense of the Indian Penal Code and the Code of Civil Procedure. Friends, it's a very odd situation for us when we are facing the COVID-19. When I was talking to many of our friends, I see that there are a lot of confusions around, right? People feel that one for words which I thought that I should share with you, that people get a bit confused on that part, and there is a overlapping of these concepts. So given current situation surrounding COVID-19, we hear a lot of terms like a curfew, lockdown, and section 144. The question here, are they all the same? But the answer is no, right? So the difference are, in case of a curfew, right? We, from our childhood, we have been, hearing the word curfew, but very few or very rare cases we hear section 144 or the lockdown. Probably in my life, lockdown I have heard the first time, and I see the quite a senior faces. Probably you might have heard in your life, but in my lifetime of 45, I've never heard about the lockdown word, right? So curfew is passed by the collector or a police commissioner, whereas section 144 is passed by the district magistrate. And a lockdown is passed by the chief medical officers and the state or the central government. Whereas curfew is normally to be followed with no movement or no gathering, right? Section 144 says the movement permitted and the gathering of more than 5 people are not permitted. So if you are standing 2 people within your premises, so it's not offense. Or if you are legitimately you are standing somewhere, but you're less than 5 people, then probably this section 144 will not be applicable to you. So the movement in case of a lockdown, the movement permitted and gathering of more than 5 people not permitted. So lockdown and a section 144 is almost the same. In a case of a curfew, all businesses and essential services closed, but the emergency services will be always open in case of a curfew. Whereas in section whereas in section 144, all the businesses closed, but the essential services and the emergency services both will be open for the public. Same in the case of the lockdown. So when we discussed about the section 144, let us understand that what should be the essence of section 144. When I have been punished or I have been charged with section 144, then what are the essence? We need to identify those essence. The essence are the obstructions of the annoyance or the injury to a person, danger to human life, health, safety, and public at large. This is something which is essentially in the COVID-19. Disturbance of public tranquility or a riot. So if the magistrate finds and satisfy by way of an evidence or a situation, in particular case of COVID-19, the situation, if he founds that there is all satisfactory reasons and any of this four, out of this four, if the one essence is satisfied, here, as I again read, is a danger to human life, health, safety of public at large. So when this essence is satisfied, the magistrate have a power, or a senior magistrate have a power to issue order in urgent cases, nuisance, or or to the dangers. The order direct an individual, certain people of an area, or a general public. Here, in a COVID-19 situation, the order is to the general public, but make sure that it can pass against the individual as well, or certain area. I'm sure you must be aware of that. We have old Ahmedabad and new Ahmedabad, right? And we have learned that now in old Ahmedabad there will be more restrictions than the new Ahmedabad, right? So it might happen that tomorrow government may say that it may not be in the entire Ahmedabad, but maybe Dani Limda or maybe Diapur or maybe Jamalpur. So particular area is also can go under section 144 and magistrate can pass the order accordingly. So who can pass the order of section 144 is the district magistrate, subdivisional magistrate, executive magistrate, who is specially empowered by the state government, right? So these are the three people who is empowered to pass the order under section 144. Now, when the magistrate is satisfied, right, and he has been empowered by the state or directed by the state, how he can pass the order. So that is something which I wanted to share with you, is that in case of an emergency, that is currently the COVID-19 pandemic situation, the order is passed ex parte. When I say ex parte, it's a legal term, but many of you must be aware that it is when there is no other side, there is no party appear, and single party go to the court and ask for the order. So usually in case of an emergency, the magistrate part the order, the ex parte. The order is passed as per section 134 of the Code of Civil Procedure, which mandate that any order or notice be served proclamation or publication in manner as the state or government direct. When 134 enforced in city or state, it was publicly informed through print and electronic media. Make sure that the section 144 cannot be ordered with the immediate effect, but it has to follow certain procedure. And therefore, if you have seen that before the section 144 applied, the electronic media was saying ke 12 વાગ્યા થી આ તારીખે 12 વાગ્યા થી section 144 લાગુ પડશે. Now what is that? That is a direction given by the state, that this, or the magistrate, that this time and this day, and this is a notice to you in electronic form which is valid under the law. So they have served you the notice at the public at large who is affecting party by this order, and therefore the direction has given by the state, or be stuck up at the place or the places as may be fittest, convenient informations to the purpose. Sometime you might have seen કે આપણે એક પોસ્ટર લગાડીને મૂકી દઈએ કે ભાઈ આ તારીખથી બંધ થઈ જશે, આ તારીખથી અમદાવાદ બંધ થશે, આ થશે. So this is like they can paste the posters, but now electronic media and the print media are more stronger to reach out to the general public, and therefore they have opted for the or the state government directed through the magistrate that this should be executed, or the notice should be served in this manner. I think I've taken 10 minutes, and I will take another 2-3 minutes for taking it further. So usually when the magistrate passed the order, so there are certain, as I said, there is a essence of the 144, that if I being a magistrate, I need to impose the section 144 or pass the order of section 144. I need to satisfy myself and understand that these are the points which are satisfactory to me, and then I can pass. But at the same time, when I'm passing the order as a magistrate, I should have certain facts or narrate certain informations in that order which will go into the public. It is mandatory under the law, the magistrate must show that the occasion is considered to be one of the emergency, and he or she must record detailed reason for passing such an order, and it should show that the magistrate has applied his mind and was satisfied about the existence of factors which I talked about, the essence for an action under section 144. Friends, if it is not properly drafted, the order is also very essential, that if it is not drafted well, then one can go to the apex court or the high court herein and the appeal court and ask for the revocation or suspension of such order. Right? So if the reasons are not satisfied or not expressed, then also that order does not exist. So friends, when in case of this, if you look at what is the main point of the order, is that he should satisfy and narrate that there is an existence of the factor to pass the order of section 144. In this COVID-19 situation, WHO has declared that the coronavirus, that is COVID-19, as a global pandemic. That itself, and has also directed all countries that they should do whatever the means possible for them to protect the citizens and the human life. So this is the declaration by the WHO, and following that, the magistrate have passed the order that, considering that or reading the WHO notifications or the declaration, there is an existence of the factor to pass 144. Recently in Ahmedabad, the district magistrate deemed in order to prevent any danger to human life and public health and safety. Thus, in terms of the power given under section 144, the district magistrate had passed a notification which prohibits the assembly of more than 5 people in public area in order to safeguard the public health and safety. As the novel coronavirus spreads easily just by coming in contact with the infected person. If more than 5 people, this is more important, if more than 5 people have gathered at a public place, not within your premises, but suppose if you are, what is a public place now? The public places that where general public access. So probably if we are setting 5 people within our camp, probably it will not be a public place. Then, as per the law, the said group will be termed as an unlawful assembly and shall be penalized for disobeying the order of the public servant, that is a magistrate herein, and can lead an imprisonment of 6 months. Friends, this is something important. People take it very lightly, but I've been told that they have now started taking the strict action. At least when I see and witness the Kulbai Tekra, where the police is started taking the stringent action. So imprisonment of the 6 months and fine, or both. Now, I'm sure many of us must be having said, why the magistrate have a right to put me under the lockdown? This is clearly against my fundamental rights. right? So Constitution of India allows me, that is Article 19(1), allows all citizens shall have the right, sub-article G, to move freely throughout the territory of India. So this is Article 19(1), sub-article G, which says that I have a right to move freely in my country, right? If this is my right, who is the magistrate, who is the state government whom I nominate or appoint, have a right to restrain me or override this? So Article 21 is also very important. We should read the protection of life and personal liberty. No person shall be deprived of his life or personal liberty, moving from one place to other and doing something in my premises or not doing something outside on the road or doing something on the road is my liberty, right? So this is the fundamental right. And there are people who may say that, and many of people might have reached to the apex court or the appeal court and saying that this is against the or ultra virus to the my constitutional right, and therefore it is not maintainable, and therefore 144 cannot be applied. But friends, the question is that at this moment in the emergency, whether the magistrate can override your fundamental right or not, the answer is very much yes. And in several cases, the Supreme Court, our apex court and the high courts have laid down that when it is the private right versus, or the private interest versus the public interest will always prevail, right? Here, in this case of the COVID-19, friends, it is a public interest, and therefore your private interest will not override the public interest, right? So this is a broad section 144. I believe that I have justified, and since I have not gone much into the technicality, but still I thought that I should touch upon the law. And there were three major concerns when I started drafting this. I thought that one is that you should know that what is your right and what you are doing right or wrong. Tomorrow it might happen that you're any representative or factory person may be punished or charged under section 144. So you should be knowing that what can be the best of this and what is this all 144 is all about. So once again, thank you very much, all of you, the chairman, vice chairman, all my executive board members. Tapan bhai, thank you for all your technical support. Thank you very much. Yeah, Bharat bhai.